Order for abattoir. Yet we about 9 constituencies and a number out. Now, and easy for to say ya force warm. They were under duress. And omode declare winner for some constituencies. Into no almost high a court, NDC and MPP court. Echo Casse. I was say easy for a quality for High Court playing and almost at a coalition. Almost a coalition. NDC for also they call Supreme Court. The apex court. Say acquire the High Court no ehema omo massive no be omo bu asem no omo ntia say nti Supreme Court no enkwase a High Court judgment no nti High Court judgment no Supreme Court tie NDC asem ekwase na omo kwase na omo ankasa NDC afa yensan fa seats no emma NDC da bi omo say omo nsan go back to High Court ho no say judge no na omo mpa a different judge na omo ni asem no foforo so aye enra 31st and omo ko pie mu High Court ni titi ensem na omo asan tu e de akose first aye ennei first na nei se me ka say rule ni nyama out eba outa e de bebrɛ nemom yankotie so far de akoso abra Supreme Court a caso fanko High Court hobium no mo kopie High Court di ko see enko hwe nyina.
We have taken note of the fact that the applicants did not contend that there had been earlier completed coalitions in respect of Nsawam Adwajiri and Ahafwano North constituencies per paragraph 8 of the affidavit sworn to by Fifi Fiabi Kwete dated 16 December in support of the motion for judicial review filed by the applicants on 16 December 2024. Since the orders which have been brought to be quashed are separate and distinct, we have decided to exercise our discretionary power to quash by certiorari, having regard to the peculiar circumstances of each ruling. Consequently, we hereby quash the orders of mandamus made for collation of results by the Electoral Commission in the following constituencies: 1. Okaikwe Central. 2. Ablekuma North. 3. Tema Central. And 4. Techiman South. Accordingly, the collation of results in the above constituencies by the Electoral Commission after 20th December 2024 on the orders of the court are hereby set aside. For the avoidance of doubt, the orders of the High Court made in respect of Nsawam Adwajiri and Ahafwano North are not affected by this order, our order, and in effect those declarations stand. Despite quashing the orders stated above, the applications for mandamus themselves are still alive and ought to be heard and determined.
The issues here basically are that the NPP, the Electoral Commission, and the NDC came to court on 4 constituencies: Techiman South, Okaikwe Central, Ablekuma North, and Tema Central. The plea of the NDC, of the NPP who are plaintiffs in this matter, is that the court should order the Electoral Commission to go back and collate results in these constituencies. These constituencies already, the results had been declared for the NDC. The NPP earlier came to the court for a mandamus application that calls for a collation, or what has become to be termed as recollation. After that, these constituencies were declared in favor of the NPP, except for the Ablekuma North constituency, where the officers were not able to complete the collation exercise. However, the NDC went to court saying that at the first time when the mandamus application was being heard, their arguments were not listened to, and that their right to natural justice, which is a right to be heard, was not upheld by the court. As a result of that, the Apex Court decided to quash the decision of the High Court. The Apex Court, however, directed the parties to return to the High Court to rehear the mandamus application to decide whether or not the EC will go back and recollate or collate the results. But before that application could be moved, the NDC's lawyer, Godwin Eduje Tameklo, moved a preliminary objection, arguing that the court lacked jurisdiction to hear the matter because of the approach that the NPP used. He argues that if you look at Section 16 and Section 20 of PNDC Law 284, People Representative Law, as amended, any issue as to whether or not a person has been validly elected or as to whether certain results should be cancelled can only be made by way of a petition to the court. Because of that, any other attempt to use any approach, such as a judicial review, as the NPP used in this manner, is a way of circumventing a proper hearing of the matter where evidence will be properly heard. The NPP, however, opposed this and argued that their case does not deal with the issue of declaring or cancelling results. Their case deals with compelling the Electoral Commission, which has a public duty, a duty to conduct elections, to supervise elections, to collate and declare results. They say that from their observations and evidence available to them, the Electoral Commission has not done that, and the Commission itself has admitted to not doing that. As a result, the court should compel the Electoral Commission to go back and do its work. The court, after listening to the parties in the case, including the Electoral Commission itself, whose lawyer also supported the idea that the mandamus application should be heard in the first place, decided that it will adjourn the case to tomorrow, January 1, 2025 at 10 a.m. and it will give a ruling. Based on the ruling of the court, we will know whether or not the mandamus application will be heard. If the court decides to hear the mandamus application, then it means that the court will now come and decide whether the EC should go back and do collation. If the court decides to uphold the preliminary objection, then perhaps this may be the final route for the NPP. As far as this route is concerned, of course, they may have the option of appealing all the way to the Supreme Court. But of course, here on Channel 1 TV, we'll bring you up to speed on all happenings here at the High Court as far as the issues are concerned. Reporting for Channel 1 News, Hansen Ajiman.
I have LORDSON TV Pro Max. So follow you. Hit the notification bell, comment and share. Which may follow your mother channel, LORDSON TV. Also subscribe. Share. If you following all other social media handles to say TikTok, Twitter, Facebook, Instagram. Other for you watching him. Every news should be about concerning the ruling. Say, or more. ECD can declare one more. Almost say yes, yeah, one more. Ever the amount or more. And I say, ruling a second. So I'm gonna say, more fana. Yes, I a question, you know, or one is I them or more. And I say, High Court Bema a easy as a quality be from. Especially 4 constituencies, you know. ɔmo quality bibi afoforo ana. In our next news, the updates ebebrew. Stay glued to your phone and to this channel. Bye bye.
LORDSON TV Pro Max.